Well, good morning, everybody. Very happy to see you here today. Well, as I said, unfortunately, I have actually a problem. I cannot show you the slides with my computer today, so I'm sorry about that. We'll try to explain you everything, to explain you very precisely. And of course, after this presentation, if you need to get the slides, I would be very glad to send it to you afterward. So the subject is actually very wide, very large when we begin to talk about the regulation of the metaverse. As of today, at least, you should know that there is actually no regulation specifically dedicated to the metaverse. However, we have current regulation, especially relating to the intellectual property, which can have an impact in the metaverse. And this is what I wanted to talk to you about today. So in terms of intellectual property law, the metaverse, of course, poses several legal challenges, including first, the brand protection, the trademark protection, and secondly, what we call the copyright in French or in Europe, droit d'auteur. Regarding the brand protection, the trademark protection, what you should know is the fact that the protection resulting from the trademarks allows its owner, this is basically what it is, to remove all its competitors from the use for commercial purposes of an identical or similar distinctive sign. Trademark law is governed by two fundamental principles, which are the extension of which to the virtual world may seem thorny sometimes, but the principle, you have first the principle of specialty on the one hand, and the principle of territoriality on the other. There is a very fundamental article of the French Intellectual Property Code, which states that the registration of the brand, of the mark, confers on its owner a right of ownership over this mark for the goods, only for the goods and services he has precisely designated. In principle, therefore, a trademark is actually protected only for the goods and services covered at the time of the filing. And this is something which is important because, as you may imagine, a lot of brand has been protected at the time the metaverse was not even here. Actually, it was here, but not as it is right now. So the main question is whether a real world good or service can be considered identical or similar to his virtual equivalent. That's actually the question a lot of lawyers just wonder when actually the metaverse begins to be what it is right now. There is actually a court case I wanted you guys to talk about. Maybe you heard about it. And this decision is really fundamental. It's in the United States, so it's not basically in France or in Europe. But I think it allows us just to question ourselves about the application of the intellectual property rights in the metaverse. So it was actually in February 2023. And once again, maybe you heard about it. The Manhattan court jury has found guilty the American artist Martin Rochi for trademark infringement, brand dilution, and cyber squatting. So what did he do exactly? Well, this American artist, Martin Rochi, he created and sold in 2021, so approximately 2 years before this court decision, without the permission of Hermes, the brand. He created and sold non-fungible tokens named Meta Birkins. And why Meta Birkins? Because they were actually associated with the digital images represented Hermes bag. And it was actually covered with some kind of a colored fur instead of leather, of course, in the way he designed it. And actually, the Rothschild NFT were first marketed for approximately $450 per unit. But after, there was some kind of resale value, like a secondary market, and some of these bags were like digital bags were actually sold for sometimes €1,000 dollars actually, and he got from that sales approximately $1 million. So this was quite a good operation for him. But you can understand, of course, that Hermes was not really happy about that, and Hermes filed actually a complaint in 2022 for damages to his brand image and invoked the risk of confusion after finding that some consumers and media had incorrectly identified Metaverse as a project supported by Hermes. So it was actually the first time that real brands important as Hermes has just troubles with the use of its image in the metaverse. And in addition to misleading consumers, they consider that the use of the name bear mark, was actually the name of the operation, would have harmed the Hermes brand and its plan to sell potentially future NFT. The artist considered like there is no problem. He maintained for his part that actually the NFT were work of art protected by the liberty of speech, the First Amendment of the American Constitution. And actually there was, according to him, no distinction between this creation and the famous Andy Warhol screen print of the Campbell's soup boxes. He actually as well highlighted a test to call the Roger test. And this test actually consider that you can, as an artist, you have the possibility to use a trademark without the authorization, provided that the work is eligible for the protection offered by this freedom of expression, and that the use of the trademark meets a minimum level of artistic relevance and does not explicitly mislead consumers. And I guess that was on that question of misleading that actually the decision has been made. And precisely February 8, 2023, the Manhattan court jury held that the artist could not avail himself of freedom of expression because actually Metaverse were similar to consumer products. It was pretty much the same, except that one is a fur, another is leather, but it was really misleading for consumers. And actually the court awarded Hermes more than $100,000 of damages for trademark infringement. Well, if I talk to you about that decision, it's because for me, this decision is actually a pioneer in trademark infringement in the metaverse. And it will definitely serve as an example for future court size or similar disputes we may have in the same sphere. So now, what to do? I don't know if in the public right now there are people who have brand and who are interested in the metaverse. I suppose that's the case. And the question is what to do to protect the brand in the metaverse. So many of brand labels have already thought about that issue. It's not something new. For example, what you can do is adapt to this virtual world by registering trademarks for product and services specifically in the metaverse. So in France, for example, you have one classification, which is classification of Nice. You have actually 45 classes in this classification. And among these 45 classes, you have actually two classes, which are really relevant and interesting if you want to protect your trademark, your brand in the metaverse. You have first the class 9 and the class 35. The class 9, it's about software, downloadable virtual goods. And the class 35 is about distribution of sales of virtual products. So what you could do is extend the protection of your trademark to the class which are not already protected. I'm talking about Europe, but it's pretty much the same in the United States with the copyright. I mean, with the trademark protection in US, sorry. So, for example, Nike, has already prepared to enter the metaverse and had made new trademark registration in the United States to adapt the trademark Nike to the class which should be protected with a warning which is actually adapted. So they did it in the United States, Nike did it in the United States, and they did it as well in France. In the restaurants sector, for example, McDonald's pretty much did the same. They had filed trademark application for the operation of virtual restaurants, okay, offering real and virtual products, and operation of an online virtual restaurant offering home delivery. So you have example of like brand already try to extend their protections to the metaverse. Same in the fashion sector, when you have actually several major brands which have taken the steps, especially in the United States patent and trademark offices, such as, for example, Tommy Hilfiger with the Tommyverse, Yves Saint Laurent with the Saint Laurentverse, or some kind of brand like that, try to extend their protection to the metaverse. Same in the sport with the Paris Saint-Germain, etc., etc., etc. Some classes are already commonly used for such repository, such as class 9, for example, for software, talk to you about, class 28 for video games, in case you want to work in video games environment, class 35, talked about, and class 38 as well for the sharing of images and videos content. So the point of my speech is just to say that there is no regulation specifically dedicated to the metaverse. In this question, however, you should anticipate and extend the protection of your brand in new classes, new environment, in order to englobe the metaverse in your protection. Okay. Last but not least, when we talk about brand and trademark, we talk about the fact to get this trademark, but we also talk about the fact to license the trademark. And in addition, it's very important to specify that the owners will have to be particularly vigilant about the licenses they may grant on their trademarks with regards to the extent of the territory and the authorized use of the trademark in the metaverse. And you need to consider that the contract you already draft about it, you already signed about it, could be modified, and of course be very attentive to the future contract you may sign to be sure that the license of the mark includes potentially the metaverse. Okay, so first subject, the brand, the trademark. Second subject, the copyright, what we call in French, droit d'auteur. So French is basically the law I know the most. And you have an article of the French Intellectual Property Code, which provides that, if you want, it protects the rights of authors to all work of the mind, regardless their genre, form, expression, merit, or purposes. And the works of the mind are actually not really defined very precisely by law. And the intellectual property rights actually just simply provide, let's say, a list, which is basically non-exhaustive of the creation, which can be protected by the droit d'auteur. And what you should know is the fact as well that when you actually assign when you transfer your work, you should, it's an obligation, have a contract, should have a copyright assignment contract with very specifically the scope of exploitation of what you are going to transfer. Which means that if you don't specify the metaverse in your contract, then automatically it could be a problem. So you should include the metaverse in actually the lists of the scope of the transfer of the assignments of in the contract. So transfer contract must imperatively determine the area of exploitation of rights, included the exploitation in the metaverse. Similarly, a company wishing to exploit, for example, an audiovisual work as an NFT, this is an example, must also mention this possibility in the contract, as it is full-fledged mode of exploitation alongside the simple exploitation of the metaverse. So the conclusion is that there is this question of the presence of the contract of the clause anticipated the mode of exploitation. Okay, let's say that you already signed contracts regarding this droit d'auteur, this copyright, and there is not the metaverse inside. In the French law, this is not like a huge problem, because you have an article we specify that you can include the mode of exploitation that are not forcible or not foreseen at the time of the signature of the contract. However, I strongly recommend you to include in your contract the metaverse as a mode of exploitation, to be sure that one there is no problem in case there is such exploitation. Okay, so as I said earlier, there is no specific regulation in the metaverse. As I said earlier, however, I consider that the biggest impact of the regulation is the metaverse is relating to the intellectual property and the copyrights, the droit d'auteur in France. There is something else I wanted to tell you guys today, is the fact that in French ecosystem, and in France especially, there is a vision of the development of the metaverse, and the government in July 2022, and this is pretty interesting, published a document entitled Exploratory Mission on the Metaverse, with the aim, with the goal to set up an exploratory mission on the development of the metaverse. And this document actually presents several propositions, and some of them are relating to the regulation. These proposals are actually relating to the development of the metaverse and its potential legislative workflow and framework. And that's really, really interesting, because we can anticipate what could happen later regarding the regulation of the metaverse. So of course, I will not talk to you about all the propositions, but only some of them which are interesting on the scope of the regulation. So the first proposal is interesting because this actually document, let's say, suggests preventive measures to consider in order to protect assets in the metaverse. So they said, okay, and we already talked about it, to register new trademarks by extending existing wording to protect digital assets in metaverse, but also consider the relevance of registering three-dimensional trademarks. So first, register the trademark on the metaverse, and secondly, don't hesitate to register three-dimensional trademarks, not only 2D but 3D. Second point, implement tools to detect illicit acts on platforms, and via complaint request the removal of counterfeit offers or other trademark violations in the metaverse. Thirdly, to acquire relevant domain names available on the blockchain, for example, with the new extension .crypto or .eth. Include the specific use of the work in metaverse in contract and licensing agreement, as I already talked to you about. To review, if necessary, modify existing license so they are actually flexible enough to work in metaverse, or actually develop new content licensing models adapted to previously granted or acquired rights, ensuring that when you actually create a virtual experience on a platform, the license obtained from a copyright holder actually really covers the scope of rights, warranties, and indemnities, duration, territory, exclusivity, sublicense, royalty, etc., etc. So everything needs to be ready in the contract. And last point is, of course, the, let's say, the education of the people, of the governance issues to the people regarding the legal impacts of the metaverse, because everybody needs to understand, especially the politics, the impact of the legal regulation in the metaverse in order to adapt the current laws and maybe one day to set up the law which will be really dedicated to the metaverse. Another proposal which is really interesting for me to consider is how to anticipate what's going to be the legal framework of the metaverse one day if finally there is this specific framework. Well, so there is the necessity to begin right now to work on adapting of course, the GDPR, the DSA, DMA, which are actually the new European regulation of the very big platform of the internet, to the challenges of the metaverse. Included another question, which is really, really important, it's the data protection. Because in the metaverse, actually, the big platform, can talk about Meta, but this is a good example, is actually able to collect so much data, to process so much data that there is a huge risk, after all, that they can get too much information about it. So data protection is really something which needs to be considered. So let's say controlling the processing of mental data, ensuring the new fundamental right, the right to respect for psychological integrity. And I guess we saw some example, unfortunately, the metaverse, which were really problematic. Analyzing our emotion, immersive technologies, and extremely invasive in terms of acquiring personal data. It's really a subject important for me. Not only if it is possible to know what a person is saying, but also what they are doing and how they are doing it. In the metaverse, you can know everything. Actually, technically on Meta, tomorrow I use Meta, I will connect myself. Tomorrow I can work on Meta, I can talk on Meta, I can have fun on Meta, I can pay on Meta. So actually, if somebody is able to know how I pay, what I pay, with who I talk, with who I work, how and when, let's say that they can collect so much data that we can even imagine. Because now, I guess everybody knows that, okay, there is no cross data collection. I mean, mainly there is no cross data collection. The banks get the information, your data about the finance. Let's say the restaurant get the data about the fact that you eat at that restaurant at that time. But if you imagine that actually there is one place we can collect all of the data at the same time, I think the risk is really huge, potentially. So actually there is an analysis of gesture that can actually provide so much information that can be risky. There is the question of the human avatar as well, in particular regarding the AI control and therefore autonomous avatars, difficulty to distinguish an avatar associated with a real human behind entirely virtual character driven by artificial intelligence. And I think this is a question which is not in the metaverse, but which is actually in the internet globally right now. And there is as well the question of the moderating behavior. Metaverse would actually pose new challenges, since they would have no longer just about moderating content, but also behavior as a whole and managing new formats often in real time. Well, last but not least, but this document actually propose let's say, privatization of investigating tools and judicial procedure, once again, regarding specifically to the metaverse, invest in tools and techniques for actually analyzing metaverse and transactions that take place on them to enable both the detection of offenses, and I guess in the public, you already heard some difficulties we had, unfortunately, especially in Meta, and I think that these tools can be really useful. French analysis tools and methods are actually essential, not only French, by the way, but for understanding and tracking what's happening in the metaverse, to identify trust offenses, of course, and as well, because there are going to be a question as well, to collect taxes. Because if you know what the person is doing, you can know when there is actually a transaction, and after you can collect taxes. And I think this is one of the goals of the state when they try to regulate the metaverse. After I talked to you about fortunately I couldn't show you my presentation, but question of law, digital body, privatization of the justice by platforms inside the metaverse, etc., etc. So let's say that if I have to make a short conclusion, I'm going to tell you that there is no regulation now so far about the metaverse, but it will come. One day or another, a lot of governments are thinking about it, working about it. That's the case of the French governments, and I hope that I'm going to be here as well to explain you the law when it will happen. Thank you very much, everybody. Sorry for not being able to show you the presentation, but once again, if there is anybody who wants to get it, don't hesitate to send me an email or a LinkedIn message, and I would be glad to share with you. Thank you very much.